Good morning, everybody. This is J.R. Whaley. With Scott Loeb, appreciate y'all being here and hope that this is a useful hour to talk about legal negligence and legal malpractice cases. Scott and I are friends from law school and work together on cases, and then also have worked against each other in cases, and in particular with negligence, legal negligence cases. And so what we intend to do today is really just give a overview of legal negligence cases, how they are prosecuted from my perspective, the plaintiff's perspective, and how they're defended from Scott's perspective, and then go through kind of in somewhat summary form some of the basics of legal negligence cases. But then also there's two new cases that have come out recently, just when I say recently, just within the last week, that we want to spend a little bit of time talking about. So that's the general outline of today. There's a couple of mechanics that we need to talk to y'all about and make sure that y'all understand. Throughout the presentation, there'll be two opportunities that the bar requires us to ensure your attendance. So if we were live, I know that most of y'all would have your laptops on and be multitasking and getting your CLE hours. I suspect that most of y'all are doing that as well in your offices or wherever you are with your laptop. But the bar requires us to ensure that you're somewhat listening. So there's going to be two opportunities throughout the hour where we have to give y'all a word, a secret password that will be asked of y'all in a follow-up email. And so that's how the bar is just kind of making sure that we lawyers are not logging on and then walking out of the room, or not doing what we typically do in CLEs, is multitask too much. So that's one of the mechanics that we wanted to make sure that y'all have a heads up. Also, the chat box, if y'all have any questions, I think the chat box should be open, and as we go through, you can either raise a hand, type a question in, and Scott and I will see those and we'll try to answer those. If not as we go along, then as we close out, we'll leave a little bit of time for any questions and answers and or discussions. You know, in live CLEs, I think that the best CLEs are the ones where there is conversation between the panelists and the audience. And so if you have a point and or you have an experience or you have a tip, then feel free, raise your virtual hand and we'll try to acknowledge that as we go along to kind of keep the conversation flowing. And then also, of course, we can unmute and just kind of have a conversation. But I guess as a first part, a little bit about me, and then I'll quit talking, and then Scott can give his kind of a little bit of background about himself. But I'm J.R. Whaley. I practice in Baton Rouge, do all complex litigation on behalf of plaintiffs, including legal malpractice cases. And so have been dealing with a lot of these issues in other professional negligence cases as well, and the preemptive issues that Scott and I will spend a lot of time about. But happy to be able to provide this CLE to y'all with Loeb Law Firm, and hope that y'all find a lot of benefit as we go through. And then I'll turn it over to Scott.
Good morning. My name's Scott Loeb. Again, JR and I have kind of worked together for and against for so long. We kept seeing a lot of trends, and I handle essentially insurance defense, broad range of insurance defense and complex litigation, and was fortunate enough when I started my practice I worked for a firm that was handling some very complex legal malpractice defense work, and felt like I was blessed enough to be trained by the best and kind of see it from all perspectives. And so JR and I were kind of shooting the breeze and talking about the things that we're seeing and the things that I'm seeing with younger lawyers that are coming into the practice, mainly in not getting the training that you may need to handle your practice. And especially in light of the competition with lawyers, I'm seeing a lot more solo practitioners out there and people hanging their shingles and young defense lawyers coming in to handle things that haven't been trained. And so we kind of put this thing together, I guess, a year and a half ago to say, look, this might be a good thing to put out there to help, not necessarily here's how you win a legal malpractice case, even though that's a large part of what this is and how you defend a legal malpractice case, but maybe to give you some takeaways, some practical things to think about that could protect you from a potential claim. Because, you know, we live in a blame, excuse, denial society, and everyone's looking for someone to blame if something goes bad. And you know, when I started practicing law was right 1998, and that's kind of right when the .com crash, the .com crash happened. And so what I got to see were a lot of businesses and a lot of individuals turn around and sue their lawyers because their business would never fail, but for, you know, if that lawyer hadn't screwed something up. And most of them were meritless, but yeah, I also got to see a lot of if the lawyer had simply protected himself, then he wouldn't have been in the situation he was in. So we have an outline and we're going to kind of go through it, but I'm going to kind of hit on some points and jump around. So if you want to go start the outline, JR, I'll get us started and you jump in and tell me
Sure.
If you've got anything to add. So, you know, and I'm going to jump through this a lot. You know, we're all lawyers. We kind of, you know, have a broad stroke or 30,000 foot view of what legal malpractice is, you know, but essentially it's a failure to perform in according to industry standards and the codes of professional conduct. And it's important to keep in mind that an unfavorable outcome in a legal matter is not sufficient to warrant legal malpractice claim. But, you know, any viable malpractice claim is going to depend on the facts of your case. And the professional misconduct is going to be intertwined with the rules of professional conduct and in essentially an ordinary man standard. Essentially, you know, what would an ordinary lawyer in that venue have done? And so it's very fact-based. A lot of what I'm seeing with some of the younger lawyers that have come to work for our firm and that I've had interactions with, they don't even know what the rules of professional conduct are. And, you know, so one of the things that I would really make sure you're familiar with are the Louisiana rules of professional conduct. And they're real simple, they're real laid out simplistically, and you can really get a feel for that. And there's also go ahead, JR.
Yeah, no, I just wanted to follow up on one of the first points that Scott made is that, you know, in fielding calls from potential clients, you know, so much of the complaints is just a bad decision. And my first question always is well, what do you think that your lawyer did wrong? You know, what do you think that your lawyer, you know, why did you lose? Why did you lose that motion? Why did you lose that trial? What happened? Obviously, you know, when lawyers miss a deadline, that's kind of easy, you know, and so the client says, well, he filed my claim too late. Okay, well, that is what I would consider a clear breach of the standard of care. I think we can all agree that we have to file things timely. Besides those kind of bright line cases, you get a lot of calls where, you know, look, the lawyer was just bad and he just didn't do a good job, or she didn't do a good job, or she missed an argument that she should have made. And that's where I think, and Scott can probably point to this well on the defense side, I think that gets to be a little bit more gray, right? I mean, that's the question about whether or not there was truly a breach of the applicable standard of care, or did the lawyer just, in that situation, his or her judgment was off, and she should have argued, red, and she argued yellow instead. Does that really rise to the level of malpractice?
I found some statistics that I thought were very interesting in the legal malpractice arena. And approximately 25% of legal malpractice cases occur through an attorney's negligence in handling the relationship with the client. And if you parse that out, that really means in the communication with the client. A lot of that's fee arrangement. That becomes more on, I deal less with the fee arrangement issues than I have with communications. And so, I was taught, and I'll give you the phrase. I think this is the best phrase that my boss taught me when writing a letter, and it's our respective files will reflect. So communicate, write, memorialize, and make sure that you are communicating with your clients. And I always write the letters, our respective files will reflect bullet point number 1, bullet point number 2, bullet point number 3. If your understanding is different from mine, please let me know. And you have that letter essentially in your file, one, to help you manage your case, but also to pull out when there's ever a criticism down the road. And so most of the cases that I've been involved with, there's been a real lack of communicating the plan of action and getting a affirmative response to that. So I would advise you make that your practice. Another takeaway would be, especially if you're doing defense work, and the defense lawyers have to keep track of their time. They bill their time in any sort of timekeeping program. We use PC Law here. I'm a big advocate of being very detailed in your time entry, and we're gonna circle back to this later when we get to the preemption prescription discussion, and I'll explain to you why that's very important. But I always, in my time entries, and would recommend that you do the same, that you, instead of just conversation with client, you put conversation with client wherein we discussed X, Y, and Z, and the client agreed. I think a lot of young lawyers don't know that, and it can come back and bite you, and it also can come back and save you if a malpractice case is ever filed. And we'll talk about that a little bit later. So let's move to the standard of care, and I'm going to go through this pretty quickly, in the sense we've talked about the Louisiana Rules of Professional Conduct. It's essentially made up of competence and diligence, and an attorney should exercise the skill and knowledge that's ordinarily possessed by attorneys under similar circumstances. And you can get that guidance from the Rules of Professional Conduct, from other lawyers, from experts in the industry. But competence is measured by the attorney's legal knowledge and skill, as well as whether you're prepared and thoroughness in your preparation. And you got to ask yourself a couple of questions if you're handling a case either on the plaintiff side or on the defense side. Is the case relatively complex or specialized? Are you experienced enough to handle this type of case? Do I need additional preparation? And do I need to consult with a lawyer that has this sort of specialty? And so I think if you walk yourself through those questions and answers, you can kind of come up with where you need to go with the case. And I always tell people, look, I'm pretty smart. I'm smart enough to know what I don't know. And when I can kind of fluff my way through a conversation, and with the reality is, okay, I realize I need to bring in an expert bankruptcy lawyer to consult with me, or an expert tax lawyer, and you can handle matters that way. So I think there is a real misunderstanding on, especially in this day and age of young lawyers that have pressure in a firm. Hey, I need to bring in work, and here I brought this work in. and I'm going to handle this case. You need to make sure if you're a young lawyer or an older lawyer that you know how to handle that case. And if you don't, then bring someone in to help you with it, or educate yourself to the point where you're confident enough to handle that matter. That's, if you don't do that, it could turn around and bite you in a malpractice claim if it goes poorly. So I also, go ahead.
Just let me jump in on that, Scott, from the plaintiff's perspective, because so many times we plaintiff lawyers will get a case and or get a call on something that is not run of the mill, and particularly, my practice, sometimes I'll get calls for, a financial injury case, and it's involves bankruptcy, or it involves taxes, or it involves something that is, for example, I'm involved right now in a kind of a minority shareholder issue. And the client came to me and wants me, but it's one of those situations is that, like Scott said, I'm smart enough to know I don't know something. Sometimes I don't know what I don't know. And you go to someone who's specializing in corporate governance and things of that nature, and you go, oh, I didn't know that. Can you learn yourself up on those issues? Sure you can. But your client shouldn't have to bear the brunt of if you get it wrong. And I think so many times, particularly with the competition, and particularly with the economics, let's say, of the practice of law, sometimes lawyers are not willing to reach out and to affiliate other lawyers who just are better in that particular area. And again, I think we always have to consider what's in the best interest of the client. Even if I'm referring the case to someone else who's going to, get the lion's share of the fee, okay, but that's my job as the lawyer for this client.
And to circle back to the communication issue, I think it's very important that you communicate that your expertise or lack of expertise to that client, and say, look, I'm willing to handle this case, but I don't know how to handle a bankruptcy. But what I'm going to do is I'm going to bring in my friend or my partner or associate who's a bankruptcy expert. We're going to work together and let the client make the decision on whether they want to go forward. So I'll give you an example. When I was a baby lawyer at my first law firm, I had a music copyright infringement case that was worth a lot of money, in my opinion, at that point. And there was a lot of pressure for the young lawyers to bring in work. And so I brought this music copyright infringement case into the firm. And I didn't even think I knew what a copyright was. So I let the client know, I don't know anything about this, but I have people in my firm that do, and we can handle it. And they made the decision, and we went forward, and we hired experts, and I learned everything I possibly could about copyrights and trademarks. And we tried the case in the Eastern District, went all the way up to the Fifth Circuit. But that's an example of, now that looking back, should I have done that? Well, maybe not. I just decided it was something I was interested in, and it was something I was willing to learn, and I was willing to bring in the senior level lawyers that knew that to help me. So I'm okay if you don't know something and you come tell me you don't know anything, and we can work through that and we can find a solution. The problem I have with lawyers that work for me or lawyers that opposing counsel is when they don't know what they're talking about and they pretend like they do, and then something will blow up that could have been handled on the front end. So preparation and communication would be the two takeaways. So burden of proof in a legal malpractice case, and in legal malpractice is a complex litigation. You've got to be able to maneuver and the landmines and make sure you understand it. So the legal elements: one, is there attorney-client relationship exist? Two, is there a breach of the duty to provide skillful and competent representation? And the breach of that duty caused harm, and the client suffered a financial loss. And we can talk all day about each one of those elements. So I think one of the most important issues is the attorney-client relationship, meaning how does that exist? So what if a client contacts you and they think you're their attorney, but you don't think you're actually there representing them? So I know JR this is a hot topic for him. I think if the client comes to see you, you need to have processes in place and say, this is how we handle a attorney-client relationship. If I'm gonna consult with you, if you're gonna hire me on a plaintiff matter, if it's a contingency fee matter, it needs to be in writing. You need to have a written engagement contingency fee agreement. If it's on the defense side or an hourly matter, then you need to have written engagement letters that spell out the scope of your relationship. And in your engagement letters, you need to say, look, I am not your lawyer until you pay me my retainer or until you sign this letter and return it to me. And you have a clear line of demarcation of when that attorney-client relationship starts.
And let me just jump in right there, Scott. Clear line of demarcation when the attorney-client relationship starts, and a very clear line of demarcation when the attorney-client relationship ends. And on the plaintiff side, that is critical because sometimes, you get hired to look into a case, you get hired to investigate the case, and come to find out it's not what the client thought at the beginning, is not what the client told you at the beginning, not what you understood the situation to be at the beginning. And you fire the client, which you have every right to do. But if you do that, it needs to be I always speak to a client like that first, but then I always follow up with a written letter for my file. And you have to do that. You have to have a process in place where anytime you discharge a client and or you get discharged, that it is in writing and it's very clear. The danger of that is when you do it too close to a deadline, a prescriptive period, a preemptive period, a court deadline, something like that. That's dangerous territory when you're discharging a client. And so you need to make sure that you're not prejudicing the client by firing them and they do not have an opportunity to hire other counsel. My form letter, when I discharge a client, says something along the lines of, there are definite time periods from which to file this lawsuit. I encourage you to contact another attorney immediately so that your rights are preserved, something along those lines. Even if I think that there is no claim there, I still put that language in there because I want, I think it's the right thing to do to the client to say, hey, and this is what I say too, is that, look, I don't see it, but I could be wrong. And so I'm not the end all be all. So, you need to go talk to another lawyer about this. And that satisfies our obligations there.
Exactly right. And so let me add something, and then we have a question that from Erica that I think is really good. So in addition to a disengagement letter, I really advise that you send the I'm not your lawyer letter if you have a consultation, just to make sure that the expectation on the part of the potential client is that I am not your lawyer. And in fact, I'll give you a real life example. I had a person come see me and we had an hour and a half conversation, and I was going to take on the case, but I ran a conflict check and ended up having a conflict. I sent I'm not your lawyer, I have a conflict, and recommended he get counsel and laid out the prescriptive periods. And he went and hired a separate lawyer. And 3 years later, I get a letter, a demand letter from a plaintiff lawyer for a legal malpractice matter. It was kind of like a Democratic grenade. Everyone got a piece of this case that had gone bad. And all I had to do was pull out that letter I had written 3 years earlier, and he left me alone. So if I didn't have that letter, I would have got sucked into that lawsuit trying to defend myself, where this particular client felt like I was his lawyer because he spent an hour with me 3 years previously. So, JR, Erica's got a question. I don't know if you can see it. I can read it to you if you can't see it.
Yeah, go ahead and read it.
It says, have you had any difficulties getting the post office to have people sign for certified mail? I started sending rejection letters via email with read receipts because local office would not require signature and would just leave registered mail, like ordinary mail. So here, the answer is yes. I have that problem all the time. Here's what I do. I send it via registered mail and I send it via regular mail. And now with the emails, I send it via email and try to get a read receipt and delivery receipt. And I think as long as you can show you have your process, whether these people sign their return receipt or not, then I think you're probably protected, because you can only do what you can do. I think if you can show you've done everything you can do to say, hey, I'm not your lawyer, or I am your lawyer, then you'll be fine. So
Yeah,
I don't know if you got anything different.
No, I think that that's right. I think that, you know, you have to show that attempt, and, but, you know, it's also kind of the due process notice issue that we see in class actions too, is that, you know, if you send the letter and it comes back, you know, returned to you for insufficient address or something like that, well, you know, you need to take that next step and do everything you can to get notice to the client. But yeah, I think, you know, belts, suspenders, you know, all those things are necessary in this situation.
And what I mean by process is this is, you know, our law firm has essentially a written process for every aspect of what we do here. So I like the fact that, you know, this is the firm process. If someone comes to see me and I don't accept the representation, I write this letter every time. So if you're looking down the barrel of a potential claim, it's great to be able to show, hey, here's our written internal process, and here's what we do for every single case, and here's my letter. It really gives you a little more extra protection to protect yourself going forward. Yeah. Okay. You want to?
Yeah, I can talk
into the timing thing.
Yeah, I think so. So we need to probably jump into the timing thing because it's important, and because time is getting away from us. But this is really the critical issue on the front end of handling a legal negligence case. There are certain rules in legal negligence cases and professional negligence cases that are, to me, counterintuitive. I always tell people, particularly non-lawyers, that, you know, the law really isn't that hard. You know, the law usually 99 point, you know, times out of 100, the law makes sense because humans want a system that makes sense, and there are some parts of law that don't make sense just from a common sense, logical, everyday man on the street. And in my view, the preemptive periods are one of that areas. So the preemptive period is found in it's Louisiana Revised Statute 9:5605. And that is for the lawyers. A lawsuit against a lawyer for legal malpractice is governed by that. And what that statute states is that no action for damages against any attorney at law duly admitted to practice in the state. And then it's a laundry list, whether it's based on tort or breach of contract or otherwise arising out of the engagement to provide legal services. So, you know, we know in Louisiana, okay, tort is a year and breach of contract is 10 years. Well, just because you have a contract with your lawyer and they screw something up, that does not make it a breach of contract case that gives you 10 years to file suit. And so any cause of action arising out of that legal engagement, and the mandatory language says shall be brought, filed in a court of competent jurisdiction and proper venue. And so we're going to get into competent jurisdiction and proper venue as well, but it has to be filed within 1 year from the date of the alleged act, omission, or neglect, or with 1 year from the date that that act has been discovered or should have been discovered. But, and this is the kicker, as to actions filed within 1 year from the date of such discovery, in all events, such actions shall be filed at the latest within 3 years from the date of the alleged act of omission or neglect. So lawyers, doctors, engineers, insurance agents have the special protection of the preemptive, the 1 and 3 year preemptive period. Those preemptive periods language is a little bit different for each one of those class of professionals. So when you are handling a case against an insurance agent, if you're handling a case against a doctor or an engineer, architect, you need to be aware that there's little nuances, differences in those preemptive periods. But since we're talking about legal malpractice, it's the doctor left a sponge in you on January 1st of 2020 during the operation. You don't discover it until January 1st, 2024, 4 years after the act. Well, too bad. Same thing with a case against a lawyer. You have to file a suit within 3 years of the act itself, regardless of when you found out about it. If you found out about it on the 364th day of the second year, well, you have a 3-year window. And so just because you discover it really close to the 3-year period doesn't give you any extension. You don't have a year from that. You have a year from discovery as long as it's no more than 3 years from the act. And so literally, I told y'all, I said, the first question I ask is what do you think your lawyer did wrong? The second question that I ask is, when did this happen? Because we don't want to take on a case that is preempted or prescribed, or that has any problems with that. And oftentimes, you get the call and you recognize that, oh, wait a minute, I don't have a year to file suit. Just because I just found out about it. I have 6 months to file suit, or I have 2 months to file suit, because by the time that the client finds out about it, you're dealing with a 3-year preemptive period. So it's a huge, huge issue. If you get a legal negligence call from the plaintiff's perspective, or you have a friend who comes to talk to you about a problem, it is the issue that you have to be careful of. So it's 1 year from the discovery under the typical discovery rule, but no more than 3 years from the act itself.
JR, let me interject on that issue, because I have seen a lot of cases on the defense side where a lawyer decided to take the representation very close to the prescriptive period, and right or wrong, missed the prescriptive period based on the information he got from his client, and now that particular lawyer has been dragged into a malpractice case.
Right.
So you just need, my advice is, if you have a client that comes to see you that's so close to the prescriptive period that you should be shooting red flags and up in the air and screaming from the rooftops, danger, 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 and decide whether you should really take on that case, because it could be problematic if you don't have time to get it together.
Yeah. And it really is one of those things that is a little counterintuitive, because you always think, okay, discovery rule, right? You got a year from the discovery. But it's not. And as we know, as Louisiana lawyers, preemptive periods, there's no suspension, there's no interruption, there's nothing. It runs. And that's that. The and the thing to remember, that it begins running from the act. So 3 years from the act. There is an exception. Up until 2015, there really was no exception to this 1 and 3 year preemptive period. But the exception is in the case of fraud. And the case that made this exception, and it really is one of those, my family, we call them BDDs, a big damn deal. The Lamont case was a BDD. It really changed the analysis, and it's Lamont versus Meyer Bennett, and it's 172 Southern 3rd 620. And before the Lamont decision, the prevailing view was that the fraud exception applied only where the fraudulent act itself was the basis of the malpractice. And those earlier courts rejected the idea that an intentional concealment of malpractice, which resulted in the client's failure to discovery, was not fraud. And in that situation, the 3 year preemptive period still held. What happened in Lamont was it had to do with divorce and a property settlement, and whether or not the lawyer had done what the client asked about a particular lien on a property. The client said, she told me that she'd taken care of it. Time passes, and come to find out the lien had not been removed. And so in that situation, the client sued the lawyer, and the lawyer said, hey, 3 years preempted. That was more than 3 years ago. And the Supreme Court went through a kind of a factual analysis and said, well, wait a minute. That just, the argument just doesn't hold water. And the only conclusion that we can make is that this was an intentional concealment, and that's not a get out of jail free card. And we're going to say that the fraud in the concealment, when you keep your client from discovering it, you don't get the benefit of the preemptive period. And that makes sense. That's one of those ones where, okay, the law makes sense there. So what we see oftentimes is, particularly on complex cases that might have gone for a long period of time, that the client is not aware of exactly how bad things had gone until they finally get kicked out or lose the case or whatever. And so in that situation, you have to really think through what are the elements of Lamont, and what can be done to allege and or to prove the fraud of concealing it. We were involved in a case recently where a lawyer, a law firm, lost a pretty significant issue, and told the client all along, no harm, no foul, no big deal. We're going to get this. We're going to get this taken care of. It's bogus decision by the trial court, and we'll get this reversed. Don't worry about it. Well, it wasn't reversed, and it was a big deal, and it cost the client a lot of money. And so in that situation, it had been long ago that the client, that the alleged malpractice occurred more than 3 years ago, and more than a year from notice. But the argument is that, there was active concealment because you kept telling me it was no big deal and don't worry about it. So the Lamont case is important. And I think that, as the years pass and more cases rely upon Lamont, we'll figure out exactly how broad that fraud exception is.
Let me, a couple of things. So one, I think I failed to announce the code word. So I picked, it's actually two words, Ghost Rider, from my favorite 1980s movie, Top Gun. So I think, so remember that word to get your free CLE. All right, so can we go back, JR, on that?
Sure.
Because I've got a couple issues. Defending a legal malpractice case, I have the most successful defense and the most aggressive attack in defending malpractice cases and defending yourself is the preemption issue. The 1 and 3 year statute, and I don't know if we said the statute, but it's revised statute 9:5605. Strongly recommend you read it and understand it. So the 1 year and the 3 year preemptive period are key defenses to malpractice cases. So remember when I said I highly recommend in your billing entries, if you're doing hourly work and keeping track of your time and how detailed your billing entries are, is the first thing that I do when I have to defend a legal malpractice case is I get the client's billing records and correspondence, and I'm looking for our respective files will reflect letters, and I look through the billing entries to see if they have detailed entry about an issue. And if you can start your time period, the 1 year from when you knew or should have known time period for a preemptive period to run vis-a-vis a detailed time entry or vis-a-vis a detailed letter or email or memo, then you can win. You can win on an exception of preemption, which is essentially a no right of action. And strategically, you file an exception of preemption, no right of action, and because it's a no right of action, you have the right to put evidence on at that hearing, and you can call witnesses and put people on the stand and cross-examine, witnesses on when they knew or should have known of this potential malpractice. And I think it's maybe a little bit too much of a deep dive, but it shows how important being very detailed on the front end and communicating those issues with your client, because if you ever do get sued, you can point to a memo or a letter and show, well, you should have done something within 1 year of receiving this letter, and now your case is preempted. So.
And, that's one thing that we have not touched on yet. And we do need to make that point, because I think this is a fair place to make it. If you're the one who blew the prescriptive period, if you're the one who failed to designate your experts by the deadline, and therefore all your experts are going to get struck, I always call it the first rule of holes, HOLES. The first rule of holes is that when you're in one, quit digging. And we're humans, we make mistakes. That's why we have insurance. And if you're the one who does it, and you're the one who has malpracticed, then you have to own that, and you have to own it with your client, and you have to own it with your client in writing. And so it's very important that that you do that, and you put your insurer on notice. And so there's all kinds of ramifications professionally, ethically, legally, if you try to conceal it, or you try to sugarcoat it, or any of those things. And so it's important that if you're in a hole, that the first rule is that you stop digging. And that does a couple of different things. It starts the clock, number one. And number two is it's just the right thing to do. And again, that's why we have insurance. And what I have seen in cases where lawyers do that, because of the fact that so many of us develop relationships with our clients during the representation, we get to know them, we know their kids, all those things, that the client is not angry. and there are opportunities for you to resolve those issues directly with your client. But you have to have the letter informing the client of, hey, I screwed up, I missed the deadline. Your interests and my interests are now disaligned, so I cannot represent you anymore. You have a claim against me for my mistake, and I think those are the elements of that letter that has to be in there. And then you should probably seek advice from another knowledgeable attorney if you want to take the next step to say, hey, I want to make this right with you. You can do that, but you definitely have to have the steps followed so that the client's informed of the problem. You acknowledge that your interests are now disaligned and that they have a claim against you, and they might want to get their own lawyer to look at it. So, that's.
Yeah, we got a question on that issue. It says, okay. Should you consult counsel before you own it? Before you write that letter?
Well, I think as any good lawyer answer is that I think it depends. I think that if you miss a prescriptive period, who are you going to go talk to that's going to tell you that's okay? If all of your experts get stricken and you don't have any evidence to put on because you've missed deadlines, well, who's going to, that's okay. But maybe there are some situations that are closer calls and you made a mistake. And is that is that a breach of the applicable standard of care because you argued red instead of yellow? Well, I don't know, maybe in that situation. But as far as, retaining lawyers, you're going to get, your insurance company is going to hire Loeb law firm to represent you because you have malpractice insurance. So
I will say this, I don't disagree with what you're saying, but I have seen, this goes back to own it, but I have seen a lot of cases where the lawyer has created a mistake, and it's not in cases as simple as missing a prescriptive period or designated experts. It's really more in a complex situations where they try to write a sugarcoat letter or like you said, some sort of sugarcoat it or try to cover their tracks, and now you've turned something that could be dealt with easily on two fronts and turned it into a fraud issue. So a lot of the bigger firms have general counsel. I would say if you have your internal general counsel, make sure you consult with them on a complex issue. And if you think it's complex and you want to make sure everyone's protected, including your client, you may want to consult your own lawyer to make sure that your client's protected and you're protected at the same time. So,
okay. So we got about 10 minutes left. We're gonna blow through a couple of these so that we can talk about two new cases at the end, and then have some also opportunity to take any more questions.
You want to announce your code word?
Yeah, since we're doing 80s movies, code words, since Ghost Rider, I think I got to go with the Karate Kid, wax on, wax off. So wax on, wax off, and Ghost Rider are the two proofs that you've been listening to Scott and me. Loeb, you want to do? You want to run through vicarious liability real quick, and then we'll do.
Yeah, look, I mean, it's like every other case. You are. There are legal malpractice issues for negligent hiring and supervision, negligent hiring, training, or supervision of employees. And so if you are a law firm, and you're hiring a young associate, young lawyer, then you have a duty as the owner or partner level lawyer to train, supervise, and make sure that lawyer doesn't do something that would, and somewhere in a car accident case, where there's a course and scope issue. So essentially, you know, if Loeb Law Firm hires an associate and that associate is negligent and commits some sort of malpractice issue, then the law firm, my law firm, is vicariously liable for the acts of my employee if that employee is in the course and scope of his employment. Course and scope being defined as, is he doing something in the furtherance of the business of the law firm? So I think we all know that concept as lawyers, both on the plaintiff and defense side. I think where the caveat in the weeds is that we have a duty to train and supervise the lawyers that work for us. And it's difficult because our time is so pulled in so many directions and billing requirements, and that sometimes the hiring, training, and supervision can get pushed to the side. So I go back to have a process in place for training lawyers and paralegals and staff. And for example, my wife is my law partner and owner, and she has created a series of training videos for our processes, how to handle cases soup to nuts. And we make all of our lawyers essentially spend the first week when they come to work for us watching those videos and going through them to make sure they understand our process and how to handle a case and where to spot a potential problem. So.
Okay. So venue is another one of those funky things about legal negligence cases. And going back to the legal malpractice statute, again, 9:5605, when I was reading it earlier, I keyed in on the fact that it had to be filed in a court of competent jurisdiction and proper venue. So what's the venue? There is a literally hot off the presses case that the First Circuit decided last week about venue. And the site is Gant, G-A-N-T versus CNA. It's a Louisiana First Circuit. The docket number, there's not even a Westlaw number yet. I think actually it might not be designated for publication, but it's a really good decision that goes through what the law is. And in that situation, and the best way to describe venue and the problems that you come up is to go through the facts of this case, which I'm going to do for the next 3 minutes, and then I'll give it to Loeb to finish about another important case that came out last week as well. But in the Gant case, it was an underlying medical malpractice case. The lawyer sends the letter to the Department of Administration, Division of Administration, says, hey, start a medical malpractice panel for these people and Emily. And the division writes back and says, okay, well, two of the people that you have named are qualified healthcare providers. Who's Emily? Give us the last name for Emily. And by the way, you owe us $100 for every qualified provider. You got 45 days to pay us. If you don't pay us, then it will have no effect. This filing will have no effect. Well, the lawyer doesn't tell him who Emily is and doesn't pay the $200. In the meantime, the defendant had filed a proceeding in St. Mary Parish saying we want a docket number for discovery purposes. After they do that, the Division of Administration says, hey man, you were supposed to tell us who Emily was and you were supposed to pay us $200 and you didn't do either one of those things. So this is dismissed. Then the defendants for the healthcare providers move for dismissal for prescription, saying, hey, look, it's been more than a year for discovery and nothing has been done correctly. Trial court agrees. Plaintiff goes to a legal malpractice lawyer, and the legal malpractice lawyer files a lawsuit the day before the 1 year anniversary of the dismissal of the underlying med mal case in St. Mary Parish. The defendant lawyer now says, hey, I live in Terrebonne Parish. And you were supposed to sue me here. Now, what's important about that argument, if they're successful, is that you have to file suit in a court of competent jurisdiction and proper venue. So under the rules is that if you file in the improper venue and you get transferred within a year of the discovery, you're good. If not, then you've got problems because you've not filed in a court of proper venue within the applicable time period. So the Louisiana First Circuit Court of Appeals goes through the analysis and looks at Code of Civil Procedure 42, which clearly says when you sue somebody, you got to sue them in their parish of domicile. Everybody says St. Mary is definitely not this lawyer's domicile. So then the question becomes, okay, is the St. Mary Parish a appropriate venue under the exceptions to the venue rules? And in that situation, the court reviews a earlier decision, J.R. earlier from this year, J.R. versus Gibbs, which it's 2020 Westlaw 3108698. And J.R., similar situation, lawyer in Baton Rouge, messes up and doesn't appropriately litigate a case in Orleans Parish. He gets sued for malpractice in Orleans, and then the court looks at it and says, well, can they be sued in Orleans? In regard to the Med-Mal case, the lawyer argued that, well, look, under the provision of the code, you have to say where the wrongful act occurred. And hey, because I didn't do anything in St. Mary Parish, that doesn't apply because there was no wrongful conduct, because there wasn't any conduct at all. I didn't do anything in St. Mary Parish. Well, the First Circuit said no dice. That is where the conduct, the wrongful conduct, the omission. Those of us who are raised Catholic know the difference between acts of commission, sins of commission, and sins of omission, and that is where the negligent act occurred in St. Mary Parish, where he failed to prosecute the case, failed to show up for a hearing on prescription. That's a real quick explanation, or not really an explanation. I want it to be more of a highlight to say, hey, if you're going to handle a legal negligence case, there are a couple of holes that you need to be aware are out there. And venue is a big one. And you need to be careful about when you file, because if you file in the wrong venue and you run out of time, then you might have prejudiced your client's legal malpractice case. Secondly, is that you need to make sure that you're filing the right venue. So Scott, I know has a brand new case that we want to talk about too before we close out after the hour.
Okay, the Louisiana Supreme Court on November 19, 2020 just came out with a new case dealing with the issue of whether collectability of the underlying judgment can be a defense in a legal malpractice case. And the name of the case is Ewing, EWING versus Westport Insurance Company et al. It's the docket number is 2020-00339. It's a really interesting case. It deals with the Supreme Court had to decide whether the plaintiff's damages in this legal malpractice action are limited to the amount that she could have actually collected on a judgment against the tortfeasor. So I know we've only got like 3 minutes, so I'll hit it pretty broad stroke, but I highly recommend you read the case. Essentially, the plaintiff lawyer fax filed his petition, but then failed to send in the original. So it was as if it was never filed, and the case was he missed his prescriptive filing period. Plaintiff hires a files a legal malpractice claim, and the defendants assert as a defense that the plaintiff's recovery could be no greater than her potential recovery in the underlying personal injury lawsuit. And they essentially were arguing that the plaintiff's recovery was limited to the amount of the insurance policy, which was $30,000. And as we all know, you have a cause of action against, a plaintiff in a personal injury case has a cause of action against a person, the amount of the insurance policy is irrelevant. Usually the case is resolved within insurance policies, but a plaintiff could seek a judgment and seek an excess judgment against that plaintiff. So there was a collectability defense in the legal malpractice arena where these particular lawyers were arguing that, look, there was only $30,000 of insurance. This particular defendant in the underlying case testified that he was going to file bankruptcy, even though he hadn't filed it yet. So therefore, had this plaintiff lawyer not missed his prescriptive deadline, he would have been limited to collecting $30,000 of insurance. Well, the Supreme Court came out and said collectability is not a defense to a legal malpractice case, and they kind of went through the the hypothetical situation of whether this particular defendant in the underlying matter would have filed bankruptcy or not, and determined that collectability could not be raised and should not be considered as a defense in this case. So it's kind of a significant issue in the legal malpractice industry. And it kind of intertwined the Jenkins versus St. Paul case, where they didn't really overturn the Jenkins case, which is kind of the preeminent case on Louisiana malpractice and in laying out the elements. And I highly recommend that you look at it. But to leave it with you, it's a money judgment rendered against a tortfeasor has an intrinsic value. That's essentially what the Louisiana Supreme Court said, regardless of collectability. Yeah. And they hold that collectability is not relevant to the correct measure of legal malpractice plaintiff's damages. So it's the financial condition of the defendant is not proper consideration in determining compensatory damages. So
all right. So look, it's 12:01. You've made it. Your hour is complete. The two pass phrases, Top Gun is for Ghost Rider, and then the Karate Kid, wax on, wax off. So those are the two words or two phrases that you'll need to respond to an email so that we can verify your attendance with the bar. That's how the game is being played these days. Look, I appreciate everybody joining. I don't know if there's any questions, Scott, that we want to just hit real fast. We're about 2 minutes over, but we can keep asking. We can answer any questions, and I guess if whoever wants to drop off can drop off. You've got your hour. Ghost Rider and wax on, wax off, and just reply to that email and you'll get your hour. But I'm happy if there's any questions that we can answer, and folks can drop off if they want to. But I can't see the questions, Scott.
We've answered the two questions that we have. We don't have any additional questions.
Okay. All right. Well, good deal. Well,
hold on. I just got one. Rachel wants to know, will a separate email be sent to enter the password?
Yes, a email is going to be sent to you, and you're going to be asked to say wax on, wax off and Ghost Rider, and that will be the information that we convey to the bar that you attended the CLA.
All
So
right.
that's the plan. All right, everybody. Thank y'all. I hope that this was helpful. And if anybody has any questions or issues and you'll want to reach out to me or Scott, our information is on the screen, and y'all can get in touch with us. So I will log out, and I think that will kick everybody out. Thank y'all.